This is continuing courtroom coverage in the trial of James Crumbley from the Hidden Killers podcast from True Crime Today. Now, back to the courtroom.
All rise, the court is now in session. The Honorable Cheryl A. presiding.
Good morning, you may be seated.
We actually just wanted to speak about timing, Judge.
Oh, all right. Did you get a copy of the expert witness jury instruction?
Judge.
Okay, if you have fill-ins for that.
I can just scratch out who we need. We don't need Dr. Bryan or Dr. Packers on this.
Does it say what Detective Weglarowski is an expert in?
Yes.
Okay. Okay. Yeah, if you give it to us, we'll change it. I want to give you a complete set of the jury instructions and make sure you agree with them.
Thank you, Judge.
All right.
May we speak with you off the record regarding timing?
Sure. All right, we had a discussion about some jury instructions where you have to make some minor tweaks, and then I'll make copies for both sides, and I'm going to provide the jury with some copies of the jury instructions as well.
Thank you, Judge.
Thank you, Your Honor.
All right. We also discussed some scheduling, and you want to recall someone, I think.
Yes, Judge. We're going to recall Special Agent Brett Brandon for very brief testimony.
All right.
Yes, Your Honor.
All right, so are you ready for the jury?
We have not heard from
Not yet. And Marc, Keast on behalf of the people.
Mariell Lehman on behalf of Mr. Crumbley.
McDonald on behalf of the people.
All right. Mr. Crumbley, can you hear us?
Yes, I can. Thank you.
All right. All right, we're going to bring the jury in.
Thank you, Judge.
Oh, yes. Should I do that? Your Honor, just very briefly, I just wanted to make a quick record before the jury comes in that Amy Crumbley and James Crumbley Sr. will not be testifying as defense witnesses. They were on the witness list, however, they are not testifying. They are in the courtroom, which is why we're making a record.
Okay.
Mr. Keast is aware. We did talk about it before coming into court this morning.
That's correct.
All right. Thank you.
Yes, Your Honor.
All rise for the jury.
Good morning. As always, thank you for being on time. You can be seated. Prosecutor, who's your next witness?
Thank you, Judge. The people are going to briefly recall Special Agent Brett Brandon.
Could you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, so help you God?
I do, Your Honor.
All right. Could you please step up and would you state your name for the record and spell your first and last name?
Yes, it's Brett Brandon, B-R-E-T-T, Brandon, B-R-A-N-D-O-N.
Go ahead.
Thank you. Good morning, sir.
Morning.
Sir, you're one of the officers in charge of this case?
Yes,
Okay. And you were here yesterday for Lieutenant Willis's testimony, is that right?
that's correct.
Okay. And you've had the opportunity as well to review surveillance footage of different facilities?
Yes,
Okay. Does that include surveillance footage of 1111 Bellevue in Detroit?
it does.
Okay. And do you recall when Lieutenant Willis was asked if he remembered if James or Jennifer Crumbley ever left the premises of 1111 Bellevue, he couldn't remember the answer?
I do recall that, yes.
Okay. Do you have a definitive answer for us?
Yes.
Tell us about that, please.
Yes. So in my review of the video from 1111 Bellevue, I did not observe Mr. or Mrs. Crumbley leave the premises. They did, like we stated yesterday, go to their car several times to smoke cigarettes and come back inside, but they did not leave the premises from what I saw in the surveillance video.
Okay, so we have surveillance video admitted already about 11:30 a.m., around noon a.m. with the time difference on the surveillance camera, that James and Jennifer Crumbley arrived in the parking lot. Is that right?
I believe that time is correct.
Okay, and then we saw footage of James Crumbley pulling the vehicle out and backing it back in the same parking spot?
Yes.
Okay, but they never left that location of 1111 Bellevue?
I did not observe them leave, no.
Okay. We heard testimony regarding certain foodstuffs were found in Suite 130 in that location.
That's correct.
In the review of your video, were you able to give us information regarding that?
Yes.
Tell us about that, please.
So in the afternoon, at some point, the owner of that art studio that they were staying in got into his vehicle, departed, returned a while later with white grocery bags, a bag of ice, and I think a case of waters that he made 3 trips in and out, carrying that into the apartment or into that unit. And then that was the person that dropped off those groceries.
Okay, thank you. I have nothing for that.
Ross?
Very briefly, Your Honor. Good morning, Agent Brandon.
Good morning.
You testified that James and Jennifer left the building, but remained on the premises.
That's correct. Yeah, they were a little out of view of the camera by the front of the vehicle, but from my observations, they would go out there for a few minutes and then walk back in.
From what you recall from your review of the information that you received during your investigation, it wasn't just once or twice, but they actually went in and out of the building multiple times that day, correct?
Yes, I don't recall the number, but it was probably north of 6, and sometimes it would be both of them, sometimes it would just be Mr. Crumbley. You know, occasionally it would be Mr. Crumbley's in particular would come out with his hood up or ball cap on and then walk back in.
And we saw it was snowing that day.
I believe it snowed in the morning, and then as the day went on, it let up. But yeah, it was approaching winter.
It was December in Michigan, so cold.
I don't recall the temperature, but yeah, it was December in Michigan.
You also, if you recall, there were times when Mr. Crumbley or his wife left the building and went back in during the day, but also at night.
Yes, it started when they arrived and then continued through the evening, yes.
As for the owner of the art studio going to get foodstuffs, I think is what the prosecution referred to it as, you don't know why he went and got it, you just know that he went and got it. Is that fair?
Correct.
No further questions, Your Honor.
No, you're right. Thank you.
All right, you may step down.
Thank you, Ron.
And who's the next witness?
Thank you, Judge. I did speak with counsel last night as well as this morning regarding our exhibits, and we approached earlier to talk about that. I will provide the court as well as counsel with our updated version. I have made a record before we started with testimony regarding exhibits that were admitted. I won't go through all of them, but I will rely upon the document that I provided counsel as well as the court that these exhibits are in fact admitted.
Yeah, we made an extensive record of which exhibits would be admitted last week, correct?
Correct, Your Honor.
That's correct. And the only exceptions that I did want to point out, we have an agreement to Exhibit 378. That's a redacted transcript of James and Jennifer Crumbley's interview video at the Oxford substation. We're in a stipulation to that. That's 378.
Ms. Lehman, did you have an opportunity to review the transcript?
I did, Your Honor. I have reviewed it. I have spoken with Mr. Keast about it, and we do have an agreement to admit that as an exhibit.
You believe it's accurate?
I do believe it's accurate, Your Honor, yes.
All right, I will admit number 378 then.
Thank you, Judge. And the only other 2 exhibits that are currently noted as exhibits on this list are 373 and 374. Those are not admitted and at this point will be omitted from the exhibit list.
373 and 374 will not be admitted.
Yes, Judge.
And Your Honor, I would like the opportunity, and I believe Mr. Keast will do that, to give me a copy of that list to just ensure that I have the same number of exhibits that he has and to make sure that we agree.
Okay, sure.
And Judge, with that, people rest.
All right. Ms. Lehman.
Yes, Your Honor. At this time, the defense would call Karen Crumbley.
Good morning. Could you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, so help you God? Okay, and could you pull this door toward you?
I got it.
And have a step up. And have a seat. And then would you state your name for the record and spell your first and last name?
Karen Crumbley, K-A-R-E-N-C-R-U-M-B-L-E-Y.
All right, I'm going to ask you to keep your voice up.
Okay.
All right, take a deep breath.
Okay.
Go ahead, Ms. Lehman.
Thank you, Your Honor. Good morning, Ms. Crumbley. Can I call you Karen?
Yes, ma'am.
Thank you. Karen, I am going to, again, ask that you keep your voice up. You are a little soft-spoken, so I want to make sure that the jury in the courtroom can hear you, okay?
Okay.
I just have a few questions. How are you feeling today?
Good.
Are you nervous?
Well, I mean, yes, a little. I mean, I'm all right.
I'm going to take you back. Well, let me start with this. Do you know James Crumbley?
Of course, yes.
How do you know him?
He is my brother.
Do you know his son?
Yes, I do.
I am going to ask that you not say his son's name. We do have some direction from the court not to use his son's name in court.
Okay.
And what is his son's relationship to you?
He is my nephew.
We're going to be fairly specific. Where do you live?
I live in Wielaka, Florida.
Tell the court a little bit about yourself.
I was raised in Jacksonville, Florida. I went and graduated high school, and then I got my medical assistant degree and did a few times in New Hampshire at Dartmouth-Hitchcock Hospital, and then came back to Florida. And I was in a car accident where I lost my right leg, and now I stay in a town that is peaceful, and I have 4 children and 2 grandchildren.
How old are your kids?
17, 18, 23, and 25.
I'm going to take you back to 2021. Where are you living in 2021?
In Wielaka, Florida.
Specifically, I'm going to ask you about April of 2021. Do you recall what was going on in April of 2021?
My mom was in the hospital. My mom passed away April 6th of 2021.
Do you recall if you saw James or his son in April of 2021?
Yes, I did. My brother James was there in the hospital with us when my mom passed. And then my nephew came down, I believe, the day after and stayed for the while we had those services, and then we had like a memorial thing, like get together with everybody, cookout and stuff, and then we had the services, the funeral services, and things like that.
You said your mom passed away on April 6th of 2021?
Yes, ma'am.
Do you remember exactly that your nephew came down on the 7th, or are you not sure of the date? And if you don't know, it's okay.
I know that they left when they found out that my mom had passed. I believe my nephew and his mother.
Let me stop you for a second. Who's they?
My nephew and his mother drove down to Florida from Michigan when they'd find out, and believe they got there maybe around on the 7th that they arrived.
Okay. So you remember that you saw your nephew maybe the 7th. It might have been the next day, or maybe you're not sure.
Right. Yes.
But it was shortly after the 6th.
Yes. It was very shortly.
While your brother and his son were in Florida, did you spend time with them?
Yes, I did.
Okay. Obviously, it was a difficult time with your mom passing away.
Yes.
Do you recall and or your nephew any other time in 2021?
Yes, I went to Michigan with my father and my stepmother to visit. It was actually he knew my father was going, but I was a surprise to my brother. And we went to Michigan. We stayed at their house for about a week.
When you
about
say
3 or 4 days, maybe.
When you say you stayed at their house, whose house did you stay at?
My brother James's house.
And was his son there?
Yes.
And you stayed there for a few days?
Yes, ma'am.
Did you spend time with James and your nephew in those few days?
Yes, ma'am.
And I'm going to ask you the same thing. Do you recall seeing anything concerning?
No.
Do you recall your nephew saying anything concerning to you?
No.
Do you recall your brother talking to you about concerning conversations he had with his son?
So I just have to object to that question. Honestly, I should object to the last question regarding April as well. She can testify as to what she observed and but not what James said or not said.
Yeah, correct, yes.
From your observations, did you see anything concerning in June of 2021?
Absolutely not.
And did you speak with your brother after June of 2021?
Yes.
Did you speak with your nephew after June of 2021?
Not directly, no. I heard him in the background, tell him I said hi, he said hi, things like that, but not directly, no.
So based on those interactions, although they weren't direct, they were kind of in the background.
Yes.
Did you observe anything concerning with your nephew between June of 21 and, we'll say, November 30th of 2021?
No.
If there had been anything concerning that you had observed, what would you have done?
I would have addressed it, and if I would have known anything, I would have talked to him, I would have took him home with me if there was any kind of inclination that anything was wrong.
Would you have made your brother aware of it?
Of course.
Did you ever make your brother aware of anything that you were concerned about?
No, because there was nothing I was concerned about.
I have no further questions, Your Honor.
Ross?
Good morning.
Good morning.
My name's Marc. I'm going to ask you some questions. If anything I ask is confusing or sometimes I kind of go on a little bit, just let me know and I can rephrase the question.
Okay.
Now, James Crumbley is your brother, obviously.
Correct.
And we refer to him as the shooter. He's your nephew.
Yes.
Okay. The last time you actually saw the shooter was June of 2021? Your nephew?
Do you mean in person?
In person, yeah. The last time you saw him?
I think, Your Honor, but she's hesitating. I think I know what she's hesitating about. Do you want to discuss it at the bench?
Can we approach? Yes. I think I know what it is too.
Okay. All right, go ahead, Mr. Keast.
Thank you. Before the shooting on November the 30th, the last time you saw your nephew was in June of 2021?
Correct.
Okay. And the last time you saw him before that was in April 2021?
Correct.
Okay. And you, from the time of actually, you may not know this, but everybody's phones in this case were seized and analyzed. Did you know that?
Yes, sir.
Okay, including your brothers as well as your nephews?
Yes, sir.
Okay. So you're not here to tell us that you had a particularly close relationship with your brother, is that right?
We had a close relationship, but we lived in two different states, so it was mainly, it wasn't like close.
Well, you wouldn't talk very often.
At least maybe once a month.
Well, according to the phone records on your brother's phone, it was far less frequent than that. Does that sound right to you? And I'm not trying to trip you up.
No. We talked on social media as well.
Right. So there's call logs, actual device to device.
Right.
Then there's Facebook calls as well.
Correct.
And I show 2 Facebook calls.
Okay.
And then there's instant messaging. And there's 22 instant messages between you and your brother.
Okay.
And that's the entire year of 2021.
Okay.
And then there's some group Facebook messages with other members of the family.
Okay.
Okay. Now, your nephew never wrote you a note that said, "Help me."
No,
did he?
sir.
And he never drew a picture next to that note with a gun, did he?
No.
Okay. And that would be concerning to you?
Yes.
Okay.
It would
And
cause.
is that what you meant to say, or is that what you meant when you said, what would you have done if you saw something of a concerning nature?
I would have brought it up, yes.
Yes, that would be something significant to you as a mother.
To address, yes, of course.
I think it might have glossed over. I want to clarify. On the phone log, there's only 3 actual phone calls between you and your brother in 2021.
Okay.
Does that sound right to you?
I guess.
Now, you were interviewed in November of 2023 by an investigator when your name was put on the defense witness list. Do you remember that interview?
Yes, sir.
Okay. And you were asked if you knew you were on the witness list, and you said that you didn't know at that point.
Right.
Okay. And then you said you would have nothing to testify on their behalf because you had no knowledge of the incident until after it happened.
Correct. I have no knowledge of the incident.
Okay. And then you said you didn't know that a gun was bought for your nephew prior to the incident.
I did not know about that weapon, no.
And during that interview, you were asked about guns in the family home back when everybody lived in Florida. And you said, well, you know, some firearms is something that wouldn't be out of the ordinary for someone to own back in Florida when you grew up.
Right,
Do
no.
you recall that?
Yes, I do
Okay.
recall that.
But then you said, having guns in the house wouldn't be out of the ordinary, but getting one for your kid would be. At 21 minutes into the interview?
Getting one as in,
Giving a gun as a...
no,
gift for
not
your
giving,
kid.
but to use at a shooting range or whatnot.
Well, I'm just
I would
reading
not see a problem.
your words, and again, I'm not
Okay.
trying to trip you up.
Yeah, no, okay.
You said getting a gun for your kid, that would be out of the ordinary.
Yes.
Thank you. Thank you.
Redirect?
Yes, Your Honor, thank you. The prosecutor asked you about guns in the family home. And you were aware, or let me ask you, were you aware in April or June of 2021 if there were firearms in James Crumbley's family home?
Yes.
And what do you know about those firearms, if anything?
I know that there was a Derringer because I saw and held it myself when I was there in June.
And how did you go about seeing and holding it?
He took it out of his room. I had brought it.
Let me stop you. Who's
Okay,
he?
sorry. My brother,
Okay.
James, took it out of his room to show, because it was, I guess it's maybe like an antique kind of ish gun. I'm not sure. I don't know really too much about them, but and I wanted to see it and I hold it, and it was very heavy. And then afterwards, he put it back in its case and brought it back into his bedroom.
Okay. You said you're not very familiar with guns, right?
Correct.
The prosecutor asked you about a statement that you made about getting a gun for your kid would be, I don't remember the word he used, odd or something along those lines. Is that right?
Yes, ma'am.
Okay. What did you mean by that? It sounded like you were trying to explain that to the prosecutor, and I don't know if we heard it.
I mean, if you're getting a gun specifically for your child to use at his leisure, that would be wrong. But with adult supervision, and I don't see any problem with it.
I have no further questions, Jim.
Just real quick, Rick Cross. When you were there in June, here in Michigan in June, I take it, right?
Yes.
Okay. And James went and showed you the .22 caliber Derringer, the small gun?
Yes.
Okay. You said he went and where he kept it in his room?
Yes, sir.
And the whole family was there?
Yes, sir.
Okay. I have nothing else. Thank you, Judge.
Well, you can step down in your excuse. I'll watch the step right there.
Yes.
All right, who's the next witness?
No further witness, Your Honor.
Revolt?
Just to confirm, Judge.
Yes. Oh, yeah, that's the Yes, yes,
I know you did.
yes.
No rebuttals.
No rebuttal. Thank you.
Just for the record, Ms. Crumbley, who just testified, is in the courtroom. I believe that, is there any objections?
No, she can say she's excused.
Are there any additional witnesses?
Not for the people.
None for the defense, Your Honor.
All right. Brooke? All right, I apologize. I was trying to see if your lunches could be here earlier. So your lunch will arrive at 11:30. Your lunch will arrive at 11:30, and we'll be hearing closings at 12:30. All right? So I need to tell you that during the trial and between now and the time that you hear closing arguments, you must not read, listen to, or watch any news reports about this case. Under the law, the evidence you consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth, and lawyers must be able to cross-examine them. Because news reports do not have to meet these standards, they can give you incorrect or misleading information that might unfairly favor one side. So to be fair to both sides, you must follow this instruction. Please do not go on social media. Please do not post, go on Facebook, do research, and discuss the case with anyone. We have come this far, all right? So please follow my instructions. You're going to be free to go. Your lunch will be delivered to your respective jury rooms at 11:30. But I have to caution you, there's people in the courthouse. There are other trials going on. There is a ton of media here. So I need to trust you to not interact with anyone or listen to anyone talking about the case. Or you get it, right? Do you guys get it? You get it?
Yes.
Okay. I've told you a lot of times, right? So at about 11:30, your lunch is going to be delivered to the jury room. At 12:30, we'll hear closings. It's hard to predict what's going to happen, when it's going to happen. So lunch will be at 11:30, and then we'll have closings at 12:30. Do you have any questions about the schedule?
Can we go outside?
Yes.
As long as we're cautious and don't talk.
Yes. It's a beautiful day. You can enjoy the sun, take a walk around our beautiful Oakland County campus.
I'm doing it every day.
You've been doing it? Okay, good, good. Whatever you want to do, just please avoid people because, not everyone is as well behaved as you at 15. Let's put it that way. All right? Anything else about that? So your lunch will be here at 11:30 and then we'll hear closings at 12:30. All right? Thank you.
All rise for the jury.
They can release the jury. Okay. So, before you depart, you did change that jury instruction, and then I'm going to give you the jury instructions. If you have a certain order, I have them in a order that I think is logical, but if you want to change any of it around, you can do it.
The only one I had noticed from last time, Judge, is they have 20.30A after 1613 instead of in the middle. Last time it was in the middle. It didn't seem to really make sense. So
20.30A and 16. Okay.
Yeah, and for reference, that would be right in front of 1615.
All right. Anything about the jury instructions, Ms. Lehman?
No, Your Honor.
I'm going to give you a set of them to make sure that you agree with them before closings.
Thank you, Your Honor.
And Ms. Lehman, would you like to inquire of your client?
I would, Your Honor. Mr. Crumbley, will you please stand up? Thank you.
Mr. Crumbley, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the true self you got?
I do.
All right, you can put your hand down. And would you state your name?
James Robert Crumbley.
All right, go ahead, Ms. Lehman.
Thank you, Your Honor. Good morning, James.
Good morning.
You know that you and I have talked about your trial. Is that right?
That is correct.
We have talked about how the trial will go.
That is correct.
You know that when you were accused and charged with these offenses, that you have the right to remain silent.
That is correct.
We discussed that that right carries through the trial.
That is correct.
You and I have discussed the whether or not you would testify during your trial.
That is correct.
We talked about the benefits of you testifying.
That is correct.
We talked about the risks of you testifying.
That is correct.
And we've talked extensively about whether or not you would testify.
That is correct.
And knowing all of that, is it your decision to testify or is your decision to remain silent?
It is my decision to remain silent.
All right. Mr. Crumbley, do you have any questions for me or do you need any further discussion with your attorney?
No, I don't believe so. Thank you,
Okay.
Your Honor.
Okay. All right. I think we're releasing the jury right now. I want to caution everyone that's here to be cautious about interacting with anyone in the courthouse. If someone were to say something or do something in front of one of the jurors, it could be devastating to this process. So I know emotions have been running high through the whole trial, and I'm just asking everybody to please, mind where you are and what you're saying and who you're interacting with. All right? Starting over would be devastating for everyone. All right? So are they released? Okay, so the jury is released. I'm going to make sure no one's in the hallway before you take them down. So we're going to have closings at 12:30.
Yes, Your Honor.
We'll have the instructions available for you before that.
Thank you, Your Honor.
Oh, 20 point. If you put them in the order you want them in,
I'll take care of it.
Copy them. Okay. So we have them. She modified the expert witness, right?
Yes.
Okay.
Thank you.
Here. So if you return them to us, we'll make a copy for each of you, and we'll also make a copy for the jury. Okay?
Thank you, Judge.
All right, so I'll see you here at 12:30. You can take the defendant, but let me make sure that there's no one in the hallway. And I'm going to ask you all to remain seated while the defendant is taken out of the courtroom. Okay. That can be.
Okay.
You didn't move anything.
We did.
This is the order.
And I'm trying to pull you live right now. You guys are going to be dead 22.
Yeah. So we may do we transfer for noon or for 5 or we're in 6. I guess he's at 5. Yeah. And I want to report to you that Mike Glover did not take me to lunch. He went out and got their own lunch. Did not come take me. So
About you.
I tried to take him out for a beer for his birthday. He says, I'm not 21. You know, we can go out some other time.
I have you.
Okay, let me get you a mic check here, okay? Okay, hold on. I'm going to give you a mic check because that's important. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. We're live.
What do you mean sideways?
This way.
I'm just going to put something out a little to her right that's still not obstructing.
Yeah. So she wants it on an angle like this, you mean?
I think straight sideways.
Like that. And then she's going to be like sideways here. Yeah, it's got to come this way too. It's hidden some.
Good or more?
Probably more. A little more.
Oh.
That thing's spinning there.
Good afternoon, you may be seated.
Your Honor, calling People v. James Crumbley, case number 22279-989 FB.
Thank you, Marc. Keast on behalf of the people.
Karen McDonald on behalf of the people.
Good afternoon, Your Honor. Mariell Lehman on behalf of James Crumbley, who is standing to my left.
Good afternoon, Mr. Crumbley. Can you hear us?
Yes, I can. Thank you, Your Honor.
All right. Are you ready for the jury?
Yes.
We are, Your Honor.
All right, I will bring them around.
All rise for the jury.
Good afternoon, you may be seated. Ladies and gentlemen, the witness testimony and the evidence portion of this trial have been completed. We will now hear the closing arguments. Much like the opening statements, these are not evidence. They're only how each side sees the case. Because the prosecutor has the burden of proof, they also have a right to rebuttal. You also will have a copy of the jury instructions at the end of the trial and when you're deliberating. Right? Prosecutor?
Good afternoon. On November 30th of 2021, around 1 o'clock in the afternoon, Lieutenant Tim Willis doesn't remember exactly what happened immediately upon being informed that there's a possible shooter at the Oxford High School. Doesn't really remember who he called or how he got down in the elevator, but he remembers one thing. Whoever he called, the first thing the caller said was, "It's real." Doesn't really remember the details on how he got there that day. But he did tell you that of all the first responder scenes he's ever experienced in his 20 plus years of being in law enforcement, this was the largest and most serious by far, and the second, what didn't even come close. Ed Wagrowski, who is now works for the Secret Service but was worked for the Sheriff's Office in the Computer Crimes Department, told you that he went so fast that he could barely keep his tires on the road. He told you that he will never forget the look on those kids' faces because they looked like zombies. He also told you that in that moment of crisis, he will never forget the looks on the parents' faces who were waiting desperately for their kid to get off those buses. Molly Darnell, a seasoned teacher who had years and years of training on what to do in an active shooter situation, she told you that even though she locked eyes with James Crumbley's son when he fired his SIG 9mm at her and hit her, she still couldn't believe she was shot. She told you that she didn't even put it together when she felt the warmth and burning on her arm. She didn't even trust herself to recognize a voice she'd known for over 20 years outside the door. And you heard from Chrissy Gibson Marshall, an assistant principal who had had hours and hours of training on what to do in an active shooting situation. And what did she do? She ran towards the shooter. She ran towards the shooter. All the training, all the preparation, and she did the opposite of what she was trained to do and what she tells everybody else to do. Because she couldn't believe it. And even when she saw James Crumbley's son with that gun, she still couldn't believe it. But she wasn't going to leave because Tate needed her help. All four of these individuals trained for years and years and years. Law enforcement, what to do in an active shooting situation. Yet, all four of them, as experienced and trained as they were, had no idea how to accept the reality that this was happening. Which is why Lieutenant Willis remembers it's real. Ladies and gentlemen, those four people, they were adults. Those four trained, experienced people were adults. These four were children. And so were the hundreds of kids in that school. What happened that day is about the deaths of these four children and what James Crumbley did and what he didn't do. The shooter has been sentenced and prosecuted and convicted. He pulled the trigger. James Crumbley is not on trial for what his son did. James Crumbley is on trial for what he did and what he didn't do. James Crumbley had a willful disregard of a known danger it caused the death of 4 students in Oxford High School on November 30th, 2021. Hana, Madisyn, Tate, and Justin. I'm going to spend a few minutes on the law, but the judge is the authority on what the law is, and she's going to instruct you what the law is. He's charged with 2 counts of involuntary manslaughter under 2 alternative theories. You don't have to find both. You don't have to agree on both. You can agree on both, but either one is the only thing necessary to return a verdict of guilty. The first is that there was gross negligence in the performance of a lawful act, and that the defendant caused death, and in doing the act that caused death, he acted in gross negligence. And then the second is his failure to perform a legal duty, and that he knew about the facts that gave rise to the duty, and he willfully neglected or refused to perform that duty, and he failed to perform it, and it grossly negligent to human life. And that the death of the victims were directly caused by defendant's failure to perform this duty. 4 counts of involuntary manslaughter for children who were killed. There can be more than one cause of death. James Crumbley doesn't get a pass because somebody else also caused the death of these 4 kids. And the judge will instruct you on that. It's not enough that he just made it possible for the deaths of Madisyn, Tate, Hana, and Justin. You must find beyond a reasonable doubt that the deaths were the natural or necessary result of his acts or failure to act. You heard the evidence about how each of those kids were killed. And as previously noted, there can be more than one cause of death. In order to find that the death of Madisyn, Tate, Hana, and Justin was caused by the defendant, you must also find beyond a reasonable doubt that his son's act of shooting someone was reasonably foreseeable. Not that he knew his son was going to kill 4 people. That is not what I have to prove. Just that it was reasonably foreseeable. What's gross negligence? It's more than carelessness. It's willfully disregarding the results to others that might follow from an act or failure to act. And in order to find that, you have to find the defendant was grossly negligent, and you must find each of the following three things beyond a reasonable doubt. First, that he knew of the danger to another. That is, he knew there was a situation that required him to take ordinary care to avoid injuring someone else. Second, that he could have avoided injuring another by using ordinary care. And third, that the defendant failed to use ordinary care to prevent injuring another one to a reasonable person. A reasonable person. And it must be apparent that the result was likely to be serious injury. In Michigan, a parent has a legal duty to exercise reasonable care to prevent the minor child from intentionally harming others or prevent the minor child from conducting themselves in a way that creates unreasonable risk of harm to others if the parent knows that they have the ability to control their minor child and knows of the necessity and opportunity for exercising such control. Even before we had safe storage, there was always a legal duty that existed. That newly passed law has no bearing on your legal duty that, as a parent, that you've always had. I said this before, there are 2 theories, 2 different ways to prove the same crime. If proven, one of these, both of them, are sufficient to establish the crime of involuntary manslaughter. And again, it's not necessary that you all agree on which theory has been proven, as long as you agree that the prosecutors proved at least one of those theories beyond a reasonable doubt. I want to stop before I talk about the evidence briefly. I want to note that everyone appreciates how much care and patience you've taken in listening. It's clear and it's obvious, and I thank you for doing that. There are people, though, who think that the prosecutor's job is just to convict people. And that's just not true. It's our job to present you with the facts and tell the truth and to be advocates, and telling the truth sometimes involves showing you things no one wants to see. Sometimes our job requires to produce evidence and testimony and pictures and images that we don't want to show you and no one wants to see them. But that's our job. That's my job. And it's not our job to sanitize, even though that would be easier. It's my job, and it's Mr. Keast's job, to present all the evidence to you and explain why we think the defendant is guilty beyond a reasonable doubt. Marc Keast told you when this trial started that any number of tragically small efforts could have saved the lives of 4 kids. That it was foreseeable and it was preventable. And the evidence presented in the last 5 days has proven that, ladies and gentlemen. James Crumbley was presented with the easiest, most glaring opportunities to prevent the deaths of these 4 students. And he did nothing. He did nothing. He did nothing over and over and over again. And the evidence shows that. This case is not about holding James Crumbley responsible for what his son did. Again, if he knew exactly what his son was going to do, he'd be charged with murder. It's about his legal duty and his failure to perform it, or to perform it in a negligent way. You heard the testimony of Molly Darnell. She told you that the first thing she saw when she looked through the window and saw the gun being raised towards her was that there was no orange tip, which she had learned previously, she doesn't remember where, meant it's a real gun. That he aimed the gun at chest level and he locked eyes with her and the bullet landed 6 inches from her heart. Ed Wagrowski, who was a member of the Computer Crimes Unit in the Oakland County Sheriff's Office. He told you about what forensic evaluation of cell phone analysis is. He was qualified as an expert. He described his involvement and observations at the school that day. And he told you that he doesn't really respond to incidents like this. He was in computer crimes. No one comes into the office and says you have to respond to a critical incident, except that day. And you could tell that that had a great emotional impact on him. He watched hours and hours and hours of videos and images of that school that day to put together the evidence that we were able to present to you today and through the past 5 days. He reviewed all of it and he described and then showed you the path and the camera angles of the shooter's path through the school that day. He also presented the messages between Jennifer and James Crumbley and the messages between their son and his friend. He told you that there were over 20,000 text messages between the shooter and that one friend he had. He also told you in 1 year there were only 65 text messages sent between James Crumbley and his father. James Crumbley, who had either worked at home, was in between jobs, or had DoorDash. James Crumbley, who was the person he dropped his son at school every single morning. He told you that the image of the gun that the shooter shared with his dad was deleted. We played the voicemail from the school on November 29th from Pam Fine talking about his son searching bullets. He presented evidence that he was aware of that because Jennifer told him about it. She texted, "Did he tell you about what happened at school?" James responded, "Yes."
More courtroom coverage in the trial of James Crumbley from the Hidden Killers podcast from True Crime Today is coming up. Press subscribe now so you don't miss a minute.